Hello everyone, I'm Anuj Jaggi and I'm a legal intern with Lexis and Company, and this is part 2 of the topic custom as a source of international law. And I'm going to pick up where I left off in the first video, which is the Anglo-Norwegian fisheries case, that is UK versus Norway. So this case was between the governments of Norway and UK. And further, both the countries had been following Norway's customary rule for about 300 years almost, from 1618 and 1608 to 1916. The customary rule was that no UK fisherman or agency or any kind of organization was allowed to enter the coastline of Norway, which was said to be a 10 mile from the coast of Norway. Conflict started when in 1911 a British traveller's ship entered the boundaries of Norway coastline for fishing. Norway government then seized the ship and arrested all the people aboard. The similar incident happened in 1948. After this, the UK government approached International Court of Justice and claimed for reduction of delimiting of the coastline boundary of the territorial claim of Norway from 10 miles to 4 miles, that is to the low waterline ground level. They also asked for the compensation from the Norway government for the seizure of the fishing ship. The issue was that whether the law adopted by Norway for delimitation, which has been shown in the government decree, was against the international law, and whether the limit of this zone was illegal or inconsistent. ICJ said that both the states had been following this customary rule for a very long period of time, and no objection was raised by British government within all these years before, and they accepted the rule and followed it too. Hence, the Britishers in beginning of the 17th century also went for fishing in the zone when the complaint was made by Norway to Britain regarding it, and since then there has been no interference from Britain to territorial jurisdiction of Norway. This shows implied consent towards the decree of Norway. So it will be very impartial and unjustified to ask the country to delimit its jurisdiction to 4 miles instead of 10 miles after 300 years of its rule over it. Furthermore, Norway extended its fishing boundary to 10 miles because the initial miles are filled with huge amounts of rocks, pebbles and etc., and which makes it totally unacceptable and inconvenient for fishermen of Norway to fish on the coastline. So they have to go ahead of it. The fishermen have to go ahead of that radius in order for the fishing purposes, and this extension of this baseline to 10 miles seems justifiable. So the judgment was presented by ICJ in favor of Norway on December 18, 1951. The monopoly for fishing in indefinite territorial water is not illegal. And then again, one of the most important cases under this is the North Sea Continental Shelf case, and in this it was in order to argue that a customary rule has emerged, one needed to prove that the objective element, that is the state practice, and the widespread and representative participation, including states whose interests were specifically affected, and the second one is a general recognition of the rule of law or legal obligation, that is opinio juris. In the North Sea Continental Shelf case, the ICJ held that the passage of a considerable period of time was unnecessary, that is the duration, to form a customary law. In summary, two elements are necessary before one could argue that a customary rule has emerged. So the objective element excuse me, the objective element, that is the existence of state practice. In other words, that the actions or omission by state must support the custom, and the subjective element is that acceptance as law. States, when performing a custom, must do so because they feel that they are legally bound by to perform the custom, which is called as the opinio juris. So further, for a customary rule to emerge, the court held that it needed very widespread and representative participation in the convention. Second, virtually uniform practice, that is undertaken in a manner that demonstrates. And third, a general recognition of the rule of law or legal obligation, that is the opinio juris. So the last case under this is the Lotus case, which is also quite important, and it was this case was about a collision occurred shortly before the midnight of the 2nd of August in 1926 between the French mail steamer Lotus and the Turkish collier Boscourt. The French mail steamer was captained by a French citizen by the name of Demons, while the Turkish collier Boscourt was captained by Hassan Bey. Lotus, the Turkish people lost 8 men after their ship cut into two and sank as a result of the collision. The French government contended that there was a customary rule of international law granting exclusive criminal jurisdiction to the state whose vessel is flying. And the ICJ rejected that the convention by pointing out that the state laws were not considered because the decisions of the state courts were in conflict. No uniform trend could be deducted from the treaties, and even publicists were divided in their views. So the various elements of a customary law that form from all these cases or all these practices were the antiquity, that is, the time is important but not indispensable in the formation of customs. The second one is uniformity of state practice. The third one is consistent state practice, and the fourth one is opinio juris, which is psychological component of customary international law. So this was the concept of customs as a source of international law, and I hope I was able to explain to you all the brief and the idea behind custom as a source of international law with all the case laws also. So thank you.